All right, welcome in everybody. For those that can, go ahead and turn those cameras on. I'd like to know who I can call on, who's going to be participating today. Welcome to your Breaking Down the Bar essay workshop today. We're gonna just like last time, just do a little bit of icebreaker, give people about 3 minutes or so to get in. Some people are still getting off work, getting situated and whatnot. But I would love to kick it off and hear some of your guys' thoughts on essay writing, how you feel about it, where you struggle with it, etc. Ashley, are you available to speak? Can you share how do you feel about essays when it comes to the bar exam? Okay, we'll take a volunteer. Anybody available to speak? It's got to be somebody. Blanca, how about yourself?
Um, I think if you prepare enough, you'll do well. My problem was I overfocused on MEEs the last time and I shortfalled on the MBEs.
Mm, yep, and did you come to the session on Monday?
Yes.
Yeah, and that was one of the things we talked about, right? Of just making sure we have a balanced approach to our studying, right? Because sometimes we'll create a new issue by trying to fix one issue. And so if you hyper focus or over focus on one portion of the exam, next thing you know, your scores drop or you just don't do as well on another portion. So yeah, definitely comes down to practice. Um, is there any particular area of essay writing that you've struggled with? Or overall, is it you know how to do on essays and it just comes down to practice for you?
It comes down to practice. I think applying the rule of law correctly and having a good organized structure with the facts um, is where I struggle. But once I get the IRAC down, that worked best for me.
Yes.
And
So a lot
working
of,
time management was another major
yeah,
problem that I,
variable. Yeah. Time management is key, right, Blanca? Everybody, we're going to talk about that here today, but you could literally be, a perfect issue spotter, a perfect analyzer, and all these things. But if our time management is off, or we're simply not getting that essay done, and depending on the jurisdiction you're in, whether it's 30 minutes or an hour, if you're just not simply getting the full issues discussed, now, you have a below passing score. And that's really the worst place to be in, essentially, if you are spotting all the right issues, remembering your rules, but that time management in and of itself can be reasons why we don't get passing scores. Okay. Um,
Hi
oh,
there.
actually,
Sorry. I was having audio issues when you called on me.
oh, no worries. Glad that you were able to jump in. So yeah, Ashley, like, what are you looking forward to getting out of this? Is there anything in particular you struggle with on when it comes to the essays?
Well, I think number one, over relying on all of the rumor mills and gossip about what is not going to be on the MEE and what will be on the MEE. We've got some concretes, right? We know exactly what's going to appear um, this time around. But I think if you're somebody like me who's like, let me get ahead of this, and you try and read every piece of literature that'll, kind of narrow down what you can expect.
The predictions and stuff,
Yeah,
yeah.
then that will kind of like set you up for failure. And then I agree with what Blanca was saying about having a good organization and a map for whatever topic you're, delving into.
Yes.
That's really important. And I've been lucky enough to look at some of the material that Legally Fit has, and it's very organized and very structured. And I think following that will help with every single topic. if you could just abide by that roadmap. And I don't necessarily abide by crack. I'm a IRAC. I'm more of a crack type of person. Conclusion first.
Mm.
And I really feel like the legally fit outlines and everything that I've seen so far has kind of organized it in that way, and that helps me.
Awesome. Well,
Yeah.
thank you for that legally fit plug for a second there. You know, highlighting our materials. We love that. But yes, you know, something that comes to mind with what you were saying is two things. One, you know, we talked on Monday about everybody being students outside of the risk zone. Outside of the risk zone means you could pass any bar exam, any jurisdiction, in any month, right? February or July. And in order to do that, you have to essentially put in the time, the concentrated work, et cetera, that I will train you on in a way that, yeah, you are not susceptible to not passing. You know every portion of the exam, you know every topic, et cetera. And all that to say, you know, as Ashley's mentioned, many of us fall into that boat at times where we're trying to game the exam and trying to predict, you know, what topics are going to be on the exam and focus more on that one versus the other. And, you know, I think the predictions can be fun. I personally don't engage in the predictions as far as making them because I stay true, even though sometimes in the back of my mind I have some feelings, but I don't even allow myself to go down that road because I stick so strongly to the philosophy that we have to be ready for everything, anything and everything. And as soon as you think you have figured out the bar exam, they will throw you for a loop. Ashley, I remember one time there was a stretch of period in California where they had tested remedies like 3 times in a row. All right. And so it was like, oh, fourth time in a row, like never going to happen. So people did not study remedies deeply and it showed up a fourth time. And then it was the next exam. And people were like, 4 times in a row, there's no way they're going to test remedies. They tested it a fifth time. Actually, they ended up testing it 6 times in a row. And every time, right, it is tripping up those students that are trying to be cheeky and game the exam. So yes, can you do that and pass? Yes. But I take the philosophy of, again, we're going to pass no matter what is on here. And then the last thing that I'll say before we jump into it, and it's the perfect transition, Ashley really got to, you know, comment a bit on what today is really about, which is performance on this exam is less about, you know, day of finessing, day of figuring things out. And it's really more so execution of what you've done in the past already. You know, think of it like any type of like, you know, final performance. You know, think about it as if you went to a play or an opera, right? The play and the opera and the people putting on that show, they're not showing up that day and doing things for the first time and trying to figure it out. And what does it mean when the orchestrator does this with his hands? Like they've gone through this time and time again. And not only have they practiced everything, they've practiced for all of the, you know, potential things that could go wrong. If this happens, then we do this. If that happens, then we do this. And that's really the same approach that you want to take to the bar exam. Bar exam is your day to not figure things out. That's your day to just simply execute. And so the real time in which, you know, you determine if you're going to pass, again, is in that preparation. And so Legally Fit is built off of strategy and templates. So that way we are routined as opposed to improvising. Okay. But yes, with that said, we are now going to officially get started. We got our room a lot more full now. Everybody's getting in off of work, school, or anything else that they were doing. I'm extremely excited to be here today. This is another free event that we put on to help students out and also showcase Legally Fit and how we help people in our program. So today's focus is going to be on essay writing, clearly is the theme. How high scoring essay writing actually works. Okay, this live workshop is going to focus on strategy, structure, and execution. Let's talk about some misconceptions when it comes to essay writing. Here's the problem. Most students think they can get by with perfectly memorizing the rules, even though most of us will never perfectly memorize every single rule on the bar exam, right? That should not be really the expectation. It could be the goal, but won't be the expectation. Spotting every single issue and sounding law school smart. We'll talk about this one a little bit more, but sounding law school smart is when, as soon as it's time to analyze, we feel as though we are on, the podium with a microphone in front of an audience, needing to sound as if we are so eloquent and so prestigious, etc., that we get away from simple, quick, and direct analysis. We get into the puffery and the unnecessary transitions and jargon that, again, are just fluff words that are trying to make us sound a certain way instead of just getting straight to it. The reality is that high scores actually come from organization and presentation, structured and simple analysis, right? Some of us may have heard the acronym before KISS, KISS. Keep it simple, stupid. All right. We can maybe find a nicer word than stupid at the end, but the message rings true when it comes to bar essay writing is keep it simple. And as simple as that sound, I will admit that there is a difficulty in learning how to communicate simply, right? And learning how to break things down where it can just be easily digestible. But once acquired, it does become easier because, again, we're not trying to sound smart. We're just communicating what we need to get across. And then lastly, and it was just mentioned a second ago, what is uber critical, extremely critical, time management. You could be the perfect memorizer, issue spotter, and all these things, but if you're not finishing your essay, that in and of itself is a reason for a grader to not pass you, right? When I get an essay and I have my checklist and I have your answer and it has, let's say, 2 out of the 4 issues, 3 out of the 4 issues, I'm already thinking I can't give this full credit. I can't give this a passing grade. Now, maybe you could try to win me over because some of that analysis was so good, or maybe the issue or issues you missed weren't the most material issues. So sometimes you can rebound from not finishing, maybe under the right circumstances. But again, you're crawling yourself out of a hole whenever your product is not a finished product. Cannot stress the importance enough of time management and always finishing your essays and your PTs. All right, let's move on now to what essentially when we're talking about your grader, what you want to help them quickly see. Again, right, it takes you 30 minutes on the UBE. It takes you an hour on California bar exams to write these essays. These graders are grading your essays in 2 to 5 minutes. So you need to be able to not only have the points on there, but make them easy to see and be awarded those points. So as a grader, what we're looking for is, did you spot enough of the right issues? Now, this enough changes from essay to essay. On the typical, let's say, California bar exam, I would say there's typically about 3 to 4 issues that are like mandatory, essential. If you didn't talk about all 3 or 4 of these, then chances are I can't pass you. And then from there, you might have an additional 2 or 3 issues that are ancillary, right? Things that you can add on that are worth the discussion, but aren't making or breaking the outcome in the essay. And so enough issues is, ideally we're spotting all of those. But if you are going to miss issues, maybe you're missing just 1 or 2 of those ancillary issues. And again, you typically want to avoid missing those mandatory. And then for the UBE exam, it's essentially everything is cut in half, right? Instead of an hour, you have 30 minutes. And instead of, let's say, 4 mandatory issues, maybe there's only 2, right? Ancillary issues, maybe there's another 1 or 2 there. So you have less margin for error on your UBE exams. Next, the relevant law, right? As a bar grader, I need to know, do you know the rules? Do you know how this works? Do you know covenants? Do you know easements or whatever it may be? And so do you have to have every rule perfectly memorized? No, but you either have it memorized or you understand it well enough that you can finesse your way through the rule and explain it in your own words. Next, you can apply the facts clearly. So for this section, right, we know that this is the bulk of the analysis. Can you organize your discussion? And then when you get into your analysis, can you apply it to the facts and make these arguments clean and concisely? We'll talk about this for sure in more detail today, and we're going to actually do a live exercise. And then next, you can reach reasonable conclusions. When it comes to the conclusions on the bar exam on essays, you have some conclusions that are slam dunk. So if you conclude incorrectly on slam dunk issues, then that is going to speak loudly, which shows either you didn't know the law, you didn't apply the facts correctly, and something went wrong. On the other hand, you have issues that are gray, issues where the outcome could go either way. And in those situations, we don't care how you conclude, just as long as you put something down. But again, these are all the things that you need, and you have to present them in a way that's easy for them to see. Where most students go wrong. One, reading too fast. How many of us can relate to getting on the exam and we just are so ready to get to writing that we forget to do some very important steps, starting with reading comprehension. When your reading comprehension is compromised, you're missing key issues. You are also missing arguments that you need to make for the parties. So one of the big things about the Legally Fit strategy we're going to practice today is really prioritizing your preparation for writing and not simply skipping through that step in a way that you want to just get to the writing. This sets your writing up to be easier and better. Next, your analysis is conclusory or it's long-winded. So this is essentially a spectrum, right? Think about it in the same way that you would in real life. Think about a person that you may know that every time you talk to them, it's like, how was your day today? Good. Okay. Anything else you want to share about it? How was it? Right? That would be an example of being conclusory, right? You're not giving me enough. On the other example, right, or the other end of the spectrum, you have long-winded. All right. I might say, hey, how was your day today? And now you've given me a 15-minute detail on how was your day, how was yesterday, how was tomorrow going to look, and now you're doing too much. And so the reality is that as bar students, we need to avoid these two extremes, and we have to find that middle ground, right, for what's the right amount. A nugget that you can take away from today to use as a guiding principle is that when you're doing an analysis, in most scenarios, you're looking for that 1-2 punch, right? That one main reason and that maybe second supplemental reason, and then move on. Could you go into more detail? Sure. But do you have time to? No, right? So again, the example would be if somebody said, how was your day? My day was great. The highlight of my day was I went to the Legally Fit session and learned how to write better essays, right? Nice in the middle, not conclusory, not long-winded. Next, poor time management, right? One of the big themes that we're seeing reoccurring in today's conversation. And again, all right, we've already talked about it. The idea is you could do everything perfectly, but if you're not finishing the essays on time or not finishing the essays, you're going to be marked accordingly. So the way that you improve time management is not the easiest. It's how you improve every other bit of your process, right? How fast do you read and comprehend the facts? How quickly can you organize your discussion and outline, right? And are you figuring that out on the spot, or are you recalling on previous experiences that expedite that process? How quickly are you making your arguments? Are you stuck in the mud, or are you relying on previous arguments you've seen before? So, I'm not a big F1, person, but I watched that movie not too long ago, that big F1 racing movie. And these people live in like seconds and even milliseconds of like trying to improve their time, right? And so when you think of it's like, well, all right, we got to shave off our time by a second. And like that is a big deal. And it sounds really easy. Oh, yeah, let's be a second faster. But the amount of things that they have to do just to get a second of improvement right, is a long list. We have to change the tires. We have to change the aerodynamics of the car, right? And all these things just to get that second off. So again, I give that example that as important as time management is, unfortunately, there's not a single thing I can point you to simply fix it. It really is a result, an outcome of how good and efficient you are with your systems, right? And to that point, most students lack a repeatable process. That is what we want here, is a repeatable process. Most students approach essays, most students approach essays with controlled panic. They're rushing through the issue spotting, remembering rules, organizing, and analyzing all at the same time, right? A lot of us can relate to this. It's the bar exam or a practice exam, and you get it, and immediately you just feel the intensity of the moment, and you're just like, all right, what are the issues? Okay, what's the rule for that? And you're just jumping around in a chaotic way, okay? This creates chaos, and that is what we want to avoid. High performing essay writing leans on routine strategy and cataloged arguments. One more time, because I want you guys to all take note of this and walk away with this today. High performing essay writing leans on routine strategy and cataloged arguments. Systems is greater than improvising. As we're going to learn today, every single time I do an essay, I have a repeatable process for my pre-writing phase and how I prepare for it. Then when it's time to get into my writing, I have a repeatable process for how I organize my answer, how I start my analysis. And then lastly, the cataloged arguments. As we learned in law school, everything about the legal industry is based off of precedent. We're not really here to be creative thinkers. We're here to know what has worked in the past and what hasn't and reuse those things. So when you're analyzing, let's say, a murder analysis where somebody killed somebody after walking in on their spouse cheating, I'm not expecting you to take the time to reinvent the wheel or analyze this from scratch. I'm expecting you to know, oh, I've seen this before. This is triggering heat of passion killing. Oh, yes. The person who killed is going to argue that there was adequate provocation of seeing their spouse cheating. And typically this is successful, as we've seen in previous situations, right? Like that is all what shit would be flooding, as opposed to trying to walk through it for the first time. This is where I like to do a quick little analogy to show you guys how, again, this is not that different from things in real life. Does anybody like to cook? Estefani, do you like to cook?
Yes, I do.
Okay, awesome. Estefani, what's one of your favorite dishes to cook?
I actually really like to cook pozole.
Okay, pozole. There we go. That is a little equivalent to my Creole dish. I'm Creole, everybody, and we like to make gumbo. So that's a complicated stew. So pozole is like a stew or soup dish, right, with a bunch of things in it.
Yeah, yeah, it's kind of like, well, yeah, it is a soup with a lot of spices.
Yes. Okay. So when you make pozole, tell me, do you go in there and at least, right? Actually, yeah, when you go in to make pozole, are you winging it and just going, every time trying to figure out what you're gonna do, or are you following a step-by-step process that you've created?
No, I have a step-by-step process that I have to follow.
And how many times would you say that you've made pozole before?
Probably about like 6 or 7 times, maybe.
Okay, so let's talk about this, right? So the first time or two that you have made pozole, right? It's like, I don't know what I'm doing. It's a little chaotic, but you probably
Yes.
started off with some training or a recipe, right? Where then it's like, all right, these are my steps. And then I'm guessing at some point you were able to ditch that recipe because now you've just embodied it and could do it on your own. Have we gotten to that part with the pozole yet?
Yes. Yes, I would say so.
There we go. Exactly. And everybody, like, let's think about the pozole in this case, right? The only way you can have a repeatable outcome of the pozole being good is if you follow the recipe every time. But if Estefani, every time she's winging it, she's coming in off of work and I don't even remember what I did last time. Did I use this much salt or this much salt? Did I use this seasoning or that seasoning? You're gonna have a different pozole every time. Sometimes it's gonna be good, sometimes it's not. But for that repeated outcome, you have to have a repeated process. And then the last thing that I want to talk about to give the analogy is the cataloged argument side. Again, you have to have certain things in your back pocket that are just ready to do so you're not trying to figure it out on the spot. When cooking, Estefani, if something is, let's say, sticking to the bottom of your pan, what are you going to do to maybe fix that situation?
Um, Probably, well, at least with other foods, probably just put like a little bit of like more oil, or if it's rice, like a little bit of water.
That's right. Let's get a little water in there, a little oil, get the stuff from sticking on the bottom, maybe turn the heat down a little bit,
Yeah.
right? These are cataloged arguments, right? Like when this happens, I know what to do. What if you're making your dish and it's a little too spicy? All right, let me add a little sweetness and that'll take it down. But if you're cooking and you don't know what to do when those things happen, you're stuck figuring it out and time is ticking, right? Now something is burning, right? So that's where the efficiency comes in. That is the equivalent of the same thing, Estefani, if I'm giving you a hypo where you break into Athena's house and actually you break into her garage, right? And it's like, oh, I've seen this before. Is the garage part of the house or not? Oh, yes. On one side, the garage is part of the house. Let me look to see if it was attached. And I'm going to try to make the argument it's the same thing. On the other side, nobody sleeps in the garage. So this is not part of the dwelling. All of that is a cataloged argument from doing that before. So thank you for helping with that analogy. And again, hopefully you guys can see what I mean by one, the repeatable strategy, that's your recipe. And then your cataloged arguments are your detailed tools of knowing what to do in common situations. All right, let's move to the next slide. So now we're going to get into Legally Fit's essay strategy. Now in today's, micro workshop, we're not going to be able to go through everything that Legally Fit offers on essay strategy, but we're going to go through a good amount for you guys to get a taste of how we train our students inside of our bar prep. So there's two phases to every essay. There's your pre-writing phase and your writing phase. The pre-writing phase is everything you do before you start writing. Just to get some more involvement, Athena, let me go to you. Athena, you might have a system that you always do. Maybe sometimes that system changes, right? But what can you recall is your common steps and the order of them whenever you get an essay? What are the things that you do before you start writing?
I usually try to identify what kind of essay is it. And
And
that's
when you say, oh, like as far as like what subject is being tested?
yes.
Okay, so one of the first things is, all right, can I ground myself with what subject this is? Okay, anything else?
And I may write down issues that I see,
Okay,
and
so I'm going to jot down some of the issues that I see.
and then I may underline some of the facts,
Okay,
and then
good.
outline.
And then you start to outline. Okay. So it sounds like we have definitely some things that we like to do in mind. And I want to now expand on that because everything that you mentioned is going to be included, but I'm going to go further and give it something that's like, boom, every time I do this, step 1, step 2, step 3, step 4. And here it is. Number 1, read the question with intention, right? Everybody's going to read the question, but a lot of times we're just reading to get through it, not reading it to really process it. Next, stop and think, all right? I can't take credit for this one. I'll have to give this one to my mother, as I'm sure other mothers have told you all. You better stop and think before you talk. You got to stop and think before you write, because when we're moving too fast, that's when we make mistakes. So stop and think for a second. Next is outline, okay? Got to create a roadmap for yourself. And then lastly is determine your strategy. We're not going to go into the detail today, but the reality is that there's some buckets that these various essays fall in, right? As far as the type of essays that they are. The most common type of essay that we know is racehorse, right? A racehorse exam. The thing is that you have to actually have a ready strategy for that type of exam. For example, if it's a racehorse, I need to know I have to move fast. That means I'm not going to make counter arguments as much as I usually do, right? I'm going to make sure I finish my pre-writing phase as quickly as possible, maybe closer to the 10-minute mark, because I need more time to write out these issues, right? So there's various strategies and also various types of essays, and that is also very important to understand before you start writing. Today, we're going to focus heavily on read the question with intention and stop and think. I'm going to first give you the lesson on it, and then we're going to go into a practice hypo. All right, read the question with intention. Let me see if I can get a volunteer here. All right, Isabella, are you with this? Can you
Yeah.
speak? Perfect. All right, so go ahead and read number 1 for us. This is our primary goal when we start to read a question.
So it's connect with the facts, humanize the fact pattern, reread sentences or paragraphs as necessary, and use the left margin to write down 1 to 2 word summaries for each paragraph.
All right, perfect. So let's pause here for a second and really emphasize what I'm saying. Typically, we default to as soon as we read a fact pattern, we're immediately just trying to spot whatever issues can organically jump out at us. What I'm asking you to do is change that order of priority. I want you to treat it as though somebody is coming into your office as an attorney that you're going to be, right? And they are telling you what's going on. You have to, right, execute a level of presence and listening and note taking and understanding of their circumstances in order to properly advise them. If you're in your head spinning your wheels about this issue, that issue, or maybe we'll win this much and maybe we'll win that much, and what about here? You're not listening, and then you're going to miss things. So we have to slow down and treat these fact patterns as just that, clients walking into our office telling us what's going on. To help us do that, I have some tools for you. On the left-hand side, you write in the margins summaries of what the paragraph is about. On the right-hand side, organically jot down any issues that are coming to mind. And when you jot down issues, right, getting into this second prong, you're simply allowing those issues to come to mind. You write it down, and then you're looking for other issues. A common mistake that we'll make is that as soon as we see the first issue, we'll have tunnel vision for that particular issue. So, oh, I see this as adverse possession in the first paragraph. And now all I'm doing is looking for the elements of adverse possession to see if it's going to be met or not. When I have trained students to go a different route, which is I see this as adverse possession. If I see any elements that pop up, sure, I'll just write that element next to that fact, but I'm no longer focused on adverse possession, right? I know it's there. I'm more so focused on, are there any other issues? And so you're kind of moving your focus from that first spotted issue to looking for the next, okay? The analogy that I like to give here is, Isabella, let's say you were a firefighter and you were going into an apartment complex that was burning down to save all the residents. Isabella, let's say you go into the house or the apartment complex and you bring out the first person, okay? What are you gonna do after you bring out that first person?
Probably like try to make sure that they're okay and to do like CPR, trying to get, I don't know what they usually do, like with
Mhm.
vitals, whatever, try to make sure that they're okay and that other people are okay.
Okay, so what you just described is essentially what we don't want to do, because if you take out that first person of the apartment complex and then you're performing CPR and you're making sure they're okay, getting them their fire blanket, what then who's suffering still?
The people that might be left inside.
Exactly. So what I want you to do with essays and in that firefighter scenario, if we ever have a career change, is you go in and you find that first issue, you find that first person and you bring them out. And then you sit them down, and they might need extra care, but you'll have to come back to them because there could be somebody still in the house who still brings. You have to go back in and find what other issues I can bring out. So it's that same level of thought process, Isabella, where again, naturally, we might want to like hone in and focus on the first thing that we find, but we have to break that habit when it comes to these essays, right? And we have to know that we'll come back to this when it's time to write.
I see. Thank you.
Awesome. All right. So that is reading the question with intention. Athena, I'm curious, give me your quick impression. Is this a little different than how you were reading the questions before?
Yeah, it is a little bit. I would try to, I wasn't writing in the margins. I would just, I had, just writing down an issue, and then go back.
Hmm. And so one of the challenges that that then does, Athena, as well, is like we have so much going on in our brains. There's so much that's being asked of us that we want to make our brain, that plate as empty as possible and not put more on it unnecessarily. So when we detach from the fact pattern and we don't mark it up in a way that we can then lean on it, you're then trying to recall all the facts and recall what happened and all those things. So very helpful tool to keep your mind as, open to analyzing, right? And the things that you have to really put your brain power to, as opposed to just holding on to these things in your head as far as facts and organization.
Really makes it
All,
T
say
because
that again.
it makes it hard for the PT because then you're flipping back and looking for it.
Oh my gosh, yes. So this is only a small habit to build for the PT because yes, with the PT, it's like times 10 of all that you have to do. So our strategy is shared for the essay and the PT. Both of them heavily rely on annotation and then going back to a well annotated document that you can refer to. But what happens, Athena, is that for our essays and PTs, if we don't annotate these fact patterns, they do become intimidating to go back to because you don't have the time to like sift through and find what you're looking for. So then you go off of your memory, and your memory may be accurate, may be incomplete, all those different things. So, yes, good catch. All right, let's go to the next slide. So, after you read the question with intention, the next thing you're going to do is stop and think. Why are the parties upset and what do they want? What is the fact pattern being oddly specific about? Or what are the elephants in the room? Two ways of asking the same question. And then lastly, again, a prompt that reminds you of how this all works. Have I seen a scenario like this before? And if so, how was it handled? You have to always be thinking in the past when it comes to legal writing, the law in general. You're thinking too, do I have a case like this? Do I have an example like this? You have to have that habit of going backwards. And then, yes, these other two questions, my favorite, I mean, all three of these are really strong questions. But the first one of why are the parties upset and what do they want? We're going to see today in our example how powerful that question is to help connect you to the issues and which issues are most important. What is the fact pattern being oddly specific about? That's also directing you in the direction of like, where are the points? If they are making something very odd or very clear, or they're like harping on something, typically that is a section that's worth more points than the others. All right. So with that said, it's hypo time. Let me go ahead and stop sharing here. I'm going to move you guys over to my iPad so we can get some markups going and some writing. Give me a second to share screen here. Awesome. All right. So can I have by a raise of hand a volunteer to go through step one, reading the question? We're going to go through that step together. If you have a volunteer, we're going to go through it together. Uh-oh.
I
You guys
can't
know.
find the raise hand feature, but I can volunteer.
Okay, awesome. All right, Estefani, let's go through it together. All right, so this is going to be an example. This essay is coming from the California bar exam from the recent administration, Feb 2026. For all my UBE students, this, as we're going to quickly learn, is going to be a property law question. This, everything that we're doing is the same as far as what we're discussing, as far as the process, how we go through it and analyze. The biggest difference that would just make this a variable for the UBE exam is that maybe instead of these three call of the questions, maybe you just had one, right? They're going to cut down the amount that you have to discuss. But for our purposes of today, again, this strategy is going to be completely applicable. All right. Estefani, again, the first thing we're going to do, as Athena said, I typically do. I don't put it in part as my pre-writing phase, but it is an honorable mention to skim the answer choices to see if we can ground ourselves with what area of law we're focused on. So we see what remedies, if any, may Reed reasonably pursue against Linda. From there, right? And let's see, Estefani, if you remember, whenever you're thinking about remedies, typically that title, remedies, is associated with three subjects. What three subjects is remedies associated with?
Contracts, torts, and
And the one we're dealing with right now.
oh, property.
That's right. Contracts, torts, and property. And most often contracts and torts, but we've seen it associated with property as well. So that lets me know from that question, right? It's one of those three. Okay. Were the developer's residential deed restrictions valid? That should tip us off that this is property. Deeds, right, are the documentation that you give to another when you are gifting property or selling property. And so that is a property term for sure. And then will Nancy succeed in her claim against Linda? So yeah, we have some hints towards property there. Now we're going to get to our first paragraph. And let's do the first paragraph where you read it gingerly. And remember, first question is to just truly process what's going on. And then I'll ask you the questions from there. But go ahead, read it as gingerly as needed to really get a sense of what's going on in that first paragraph.
Okay. Olivia owned a house in Havenwood, a subdivision with 15 homes on large wooded lots. The developer of Havenwood had conveyed each lot, including Olivia's, by a recorded deed stating that the conveyance was for residential purposes.
Okay. So now I need you. This is what I always like to also teach and share. The bar exam is hard, right? Law is complex, but we can have fun with this and we can humanize this. So, Estefani, in your own words, what is paragraph one saying?
That Olivia has one of the houses in a 15, like in a big lot, basically.
Okay. In real world, what does that typically look like? A subdivision. What do we typically call that in real life? A lot of
Um,
times it's like a gated community, right? We think of, right? There's little subdivisions. They're not always a gate, but that's one popular type. It has a gate to get into it. But yeah, it's like, a gated community or in the suburbs, like it's a particular area for, that development. And so we have one of those. And then you missed out also a key thing. Olivia bought a house there, but what's also something that we know about this subdivision?
that it's that there's 15 other homes and they're on wooded lots.
We're not too worried about the
Oh,
large
okay.
wooded lots, right? I can't imagine there's any property doctrine that's gonna, come down to was it wooded versus iron, anything like that. What else do we know that the fact pattern is telling us that seems to be important? Something about this subdivision.
That the developer gave this lot to Olivia through a convey or saying through a deed, a recorded deed. And the deed stated that the conveyance was for residential purposes.
Yes. Okay. And so again, Estefani, like we're not quite getting there in that way where I want this level of simplicity and comfort with what's going on. My version of simplifying that is Olivia
Mhm.
bought a house in some type of gated community subdivision, and the developer made up a rule that the all the homes in here had to be used for residential purposes. Which means what, Estefani? If it can only be used for residential purposes, typically that means you cannot.
You cannot use it, or you can't use it for anything other than that.
And what's the typical other
Oh,
thing? Hmm.
um, for like businesses or a business
Exactly. So
purpose.
whenever you zone something for residential purposes, it's like, yep, this is not for business or commercial use, right? Exactly. So again, this is the type of like connection that right there I want you to be making of like, oh, this is only for residential purposes, meaning no commercial. The developer, I would say it's important. He had put it in each lot. He conveyed each lot with a recorded deed. The fact that it was recorded is always important in property law, so we'll underline that it had to be for residential purposes. On the left-hand side, I'm going to write a 1 to 2 word summary of what this paragraph is about, right? Because as me and Athena talked about, we need to annotate this. So if I need to come back, I know where to go back to. I'm just going to write subdivision here because this is a paragraph introducing the subdivision. Another thing that I like to do, and again, I'll do it quickly as I'm initially reading, is I like to diagram. So I might do something like this, right? Let's get rid of this title. I might do something like this. I might do this to represent there's 15 lots, and then I'll say Olivia has one. And then I'll put HW here. Havenwood is the name of the subdivision. Okay. Now, last thing, and Estefani, and also everybody else, feel free to participate in the chat. We can now do our secondary goal through that first paragraph, which is, do I see any soft triggers here? Soft triggers meaning, does any area of law come to mind based off of those facts that we have in that paragraph? So, Estefani, you can go ahead and speak, and then again, anybody can put it in the chat of any soft triggers.
I saw someone put it on the chat, but I was gonna say that too: equitable servitude, real covenants, and the other one that comes to my head, I don't know why I got stuck with large wooded lots, but waste. I don't know if that will be useful later.
Okay, I would say that waste is going to come up on this essay. And right, I'm guessing you did take the February 2026 exam and you've done this question before, right?
I did.
So yeah, waste is going to come up, but I would say here there's nothing that softly triggers waste, right? Waste is all about, destroying the property, causing damage in some way, etc. And so here we just have very generic information. So I wouldn't say this is a soft trigger for waste. I also wouldn't say that this is necessarily triggering real covenants and equitable servitudes yet, because we're waiting for, but I guess you could still put a soft trigger for it. But what I would really want to put down the soft trigger for is implied reciprocal servitudes, because that is specifically the very particular area of property law that deals with what, Estefani?
I actually don't know
Yeah.
what it deals with.
So that's the one that specifically deals with subdivisions, right? Like that whole
Okay.
section is about subdivisions and somebody not having the covenant in their deed, but the rest of the subdivision has to follow it. So can we imply it on that person as well? So this is a big trigger for that. And then secondarily, yeah, we could write covenants as well, including real covenant and equitable servitude. Awesome. All right, let's go to the next paragraph. When Olivia died last year, okay, so I'm going to just underline Olivia died. She bequeathed, translate that. What does bequeathed mean?
She gave.
Yeah, she gave, and typically at death. So she gave a life estate in her house to Linda, leaving the remainder to Reed. Life estate and remainders come from what chapter in property law?
Um,
That's going to be present estates and future interest. So, boom, we
okay.
would do a soft little trigger there. Linda already owned a house. And then also, let's just document this, right? So you have Olivia to Linda for life, and then Reed equals vested remainder. So we have this documented. It says Linda already owned a house and wanted to use Olivia's previous house as a florist shop instead of, or I'm sorry, instead. Shortly after taking title, and so again, I'm gonna do this as kind of like if it was me doing it. I'm gonna translate that like, okay, I already see the problem that's about to occur here. This is only for residential purposes. And she's like, I already got a house. I want to use this for a business. That's all I'm interpreting that as. She wants a floor shop. That's a business. That's a problem. Shortly after taking title, Linda cut down valuable mature trees and privacy hedges to on the lot to make room for parking. Right? Would you say that this is a fact that's oddly specific, Estefani?
I want to say yes.
Yeah, absolutely. It's like, why are you telling me that, right? Like, she wants to do a florist shop, and then you're getting down to, oh, she cut down valuable, mature, like, and look at the detail and the adjectives. She
Mm.
cut down valuable, mature trees and privacy hedges to make room for parking. That's oddly specific. I got to do something with that. I know what it is, but I want to replicate sometimes situations in which it's like, that has to be something. I just don't know what it is yet. Linda then obtained a construction permit to renovate the house and a license to operate her business. So she went ahead and got the proper documentation and go ahead from the city to operate her business. Linda's renovation reduced the square footage of the house from approximately 5,000 square feet to 2,000 square feet, which significantly reduced the value of the structure. Again, more just very specific detail, right? And at the end of the day, this has reduced the square footage, and now we have reduced the value of the structure. Again, some of us may be spotting what this is already. I want to show you that what you do in situations where it's like, I know this is triggering something, I just don't know what it is. We're going to act as though right now we don't know what that is, but that's why we have a question mark. On the left-hand side, Estefani, let's see if we're getting this down. What would be a 1 to 2 word summary of this paragraph that you would do?
Um, Probably, oh God, I feel like this is a
Don't overthink it.
tricky
This is
one for
simple.
me.
Yeah, exactly. Difficulty in the simplicity, right? It's just what is this paragraph
Yeah,
about? There's no right or wrong answer here, but it's just like you need to
that
summarize what this paragraph is.
that Linda owns, well, Linda owns a house. Um, Reed has the remainder, and Linda now.
We can much beyond 1 to 2 word summary.
Oh,
So look, I'll give you another one with this one, and then you'll try the third one more time. I'll go,
okay.
this is about Linda's business. And that's enough for me to just remember that, like, yeah, she opened up a business, which is the problem, right? And this is supposed to be for residential only. You can also put, if you wanted to have two things here, you can move down L's business, and then you can also put this is O to L plus R, right? O to L plus R, and then yeah, it was also about L's business.
Okay.
So you see what I'm saying there? Like short and sweet,
Yes.
just like what's about, yeah.
Yes, yes.
And
This
again, it
is
only
way
gets
shorter.
yes, and it gets way better with practice. All right. So last paragraph. Nancy, one of Linda's neighbors in the subdivision, threatened to sue Linda for violating the residential covenant in Olivia's original deed. All right, so now we have a new party. We typically want to like make sure we underline or highlight new parties. And we can go back to and make sure we do that. We have all our parties now. We got Linda, we got Olivia, we got Reed, and now we have Nancy. This is one of Linda's neighbors, threatened to sue Linda. All right, so now we know this is going to call a question 3. threatened to sue Linda for violating the residential covenant in Olivia's original deed. However, Linda pointed out to Nancy that 5 other businesses had been operating out of homes in the subdivision for over 10 years, including 2 coffee shops, 2 clothing stores, and a dry cleaner. And neither Nancy nor other lot owners had complained previously. This is a very interesting situation, in fact, not one that is typically common. But what's the essence, Estefani, in your own words, of this back and forth between Nancy and Linda here?
Nancy sues Linda.
Yeah, and that's like our yes, that's our work, that's our summary we're gonna write here to recap it. But I want reading comprehension to make sure we get all of what's going
Oh,
on,
okay.
how the parties are presented. But I do like that as our 1 to 2 word summary. So good job there. But yeah, you can now expand of just what you're telling yourself in your mind of what this paragraph is telling us.
Um, that, let me see this. Well, I guess that Nancy threatens to sue Linda because now Linda wants to use the space
Mm-hmm.
for business purposes.
Mm. Let me pause you again, because again,
Yes.
this is going to be a good practice exercise, right, as we go through bar prep. Because again, I want you to loosen it up and have fun with it, as if you're talking to your sister, your friend, your parent, etc. Right? Here's another example as far as again how you can talk to yourself about the facts. For this
Mhm.
paragraph, I would say, all right, we got a whistleblowing neighbor, right? The whistleblowing neighbor here is Nancy. Nancy's upset, and now Nancy, the neighbor, wants to sue, right? Which is interesting because again, it's like, Nancy didn't sell the house to Linda, but
Yes.
Nancy's basically like, hey, we all live in this subdivision and you're not supposed to run businesses in here. So she's like, you can't run that business, right? And then the facts give us what almost is going to be, the basis of Linda's argument or defense, which is, well, why are you coming after me? There's 5 other businesses that have been operating out of homes in the subdivision for over 10 years, and you nor anybody else has ever complained about those before. Just out of quick gut feeling, Estefani, what do you think the strength of that argument in isolation is going to be? Do you think it's going to be a very strong argument to support Linda, or not so strong of an argument?
I think it would be a strong argument to support Linda.
Okay. And then I'm curious, let's get it in the chat as well. Do you guys think it's going to be a strong argument or not so strong? And then verbally, Athena, what's your thought? Do you think that's going to be a strong argument or not so strong?
I think it's a strong argument, and I started wondering if because she didn't complain about the other businesses, she may not have a right to sue now.
Have you ever seen a rule that tells us that?
Yes, and it's right in my brain somewhere.
Oh, and I'm still looking for it in my brain because I've never seen that rule before. I've never seen a rule that tells us that you lose your right to sue, right, or anything like that if you fail to exercise that right later, right? There is one other area of law that's like lapse, right, and things like that. That's a whole different area of law, and that's for equitable remedies, and it's a whole other thing. But what happens, Athena, in my opinion, this is one of those areas where they're throwing a curveball at you that kind of like will emotionally pull at you to get you to analyze a certain way. But I would almost say this is the equivalent, right, Athena? If let's say you get pulled over, is and you get pulled over for speeding, and if can you say to the officer, well, why'd you pull me over? There was 5 other cars that was driving really fast, and you didn't pull them over. Is that going to be a strong argument then?
No.
Yeah, absolutely not. Like, hey, we decided to pull you over. So I think we're gonna lean more into that, But again, I will look at to we'll look at our outline and see what is that one area of property law for those equitable remedies where you have to do so within a reasonable time. But that's not this. That's more so. I can remember the doctor at the top of the head, my top of my head, but that is more so when somebody is doing something and instead of suing them immediately, you let them keep doing what they're doing. They keep building that property that's over your property line, even though you know that it's over. And then you wait, a year to then be like, oh, sorry, you got to take it down. Like that's that situation. So, yeah, maybe that'll be there. But again, I don't think under these circumstances it would be. But yes, so let's go ahead and put a question mark for that defense.
A time waster.
Because regardless, it is something they're oddly specific about. So we know we need to like talk about it, right? Like there's a whole 1 and 2 about it. So we do know we need to talk about it. All right. So yeah, I think as far as a summary goes, N versus L is very good here. Um, and then while we're at it, let's just go ahead. Let me go back out of here. Let me go into my remedies outline. And let's see if we can get that. So it's latches. So equity relief will be denied when the plaintiff unreasonably delays in initiating his equitable claim and that delay results in prejudice to the defendant. All right. So again, I think that could be possibly worth a discussion here, but I don't think it's going to be a strong argument because it seems as though with Nancy versus Linda, there was no delay in bringing it against Linda. Linda's claiming you just didn't bring it against other people. But let's make the arguments there. All right. So, Estefani, are we understanding and seeing this different way of going through the reading of the question?
Yes, yes, it's making a lot more sense.
Yes. And so one of the things that I want you to practice, and I'm telling you, you're not the only one, because a lot of us, we don't treat questions like this where we humanize it and keep it light. So yeah, that's something to keep in mind to practice is like, all right, how do I translate this? And the reason why we want to do this, Estefani, is that one, it lowers the pressure and the nerves of it all. But two, when you start translating every single essay into your own words, that's when you start to see the patterns. That's when you're like, oh yeah, I've seen this before because you've translated it in that way. So let's next go into our stop and think questions. All right.
Okay.
And then I'll see if we get another volunteer. Amanda, can you speak? Okay. How about Daryl? All right, last attempt. Let's go back to Ashley. Ashley, you there? Ooh,
I'm
I
here.
can be Holland.
there we go. All right, Ashley. So let's go into our stop and think questions. So the first question is why are the parties upset and what do they want? All right. So the first party that we have is Olivia. Is Olivia upset and want anything?
No.
No,
Let's
Olivia is
hope
no
not.
longer. Yeah, Olivia is no longer with us. Olivia died last year, so Olivia is out of this. Um, okay, and so then next you have the next party is going to be Linda. Why is Linda simply upset?
Linda's upset because the neighborhood has pretty much turned into a mixed use situation and she doesn't want any more businesses.
That's not why
Oh,
Linda's upset.
sorry. I'm confused. Who's the neighbor?
Yes, and that
Sorry.
happens, right? Exactly. Good, good, good. So
Yeah,
that was
so
Nancy. So Nancy's upset because of this whole, yeah, what is this? Turning into a circus subdivision? It's supposed to be for residential living. This is turning into mixed use. So I like that. Using your own words there to just summarize what's going on. But yeah, why is Linda upset?
and Linda's upset because she wants to run her florist shop.
She wants to run her business and Nancy is getting in the way.
Right.
Good. And then why is Reed upset?
Mm, I don't remember what Reed's part was in this whole thing.
Yes. So leaving the remainder to Reed. So Reed gets the house after Linda. So
Okay, so
so think about it, right? Like why would Reed be upset here?
So, now I have to make sure I got the party straight.
Mhm.
Um, so Linda now has cut down a bunch of trees to
Trees,
make a
hedges,
parking lot,
and she's
which
also reduced the square footage.
impacts Reed ultimately because he's the remainder here.
Yeah. So, and real quick, you got it. Real quick summary. Like, why is Reed upset?
Because Reed's gonna have a smaller house.
Yeah, you're ruining the house that I'm gonna get, right? That is Reed's reducing value of house. Now, this is where I was saying, like, if you were struggling with what organically was coming to you, right? Like in your initial read, like here we said, man, I just don't know what this is. Sometimes when you go through your stop and think questions and you figure out why the parties are upset, then certain areas of law pop out. If Reed is upset because somebody before him that he's connected to this property and somebody else is reducing the value of that property, what area of property law handles that situation?
Are we talking about ameliorative waste?
Exactly. It's going to be the category of waste, right? And then there's different types, and we can get into the different ones, but there you go. So again, Ashley, you see what I'm saying on how we can connect, like why, who's upset, who are my parties and why they're upset, and how that starts to help issue spot as well. Yeah. So waste is it, and then again, you can then from there put a placeholder because you have to make your outline, and then of course you want to know what different types of waste that you'll be discussing. All right, but that's the question there. And then let's talk really quickly about Elle running her business and Nancy not. Again, you just want to kind of like ground yourself in what this is all about. At the end of the day, the original homeowners here in this situation were O and developer. And then O ended up giving the house to Linda. Do we have any record that in the bequeath, in the conveyance from O to Linda, that it said that it can only be used for residential purposes?
No, but it says that the recorded deed
But
for
that's not my
everybody.
question. That's not
Oh,
my question. Just say, yeah, right now it's just like, was it in her deed? Because that's always the basis of the argument, right? Linda is saying, well, that wasn't in my agreement, right? And so now then we go to the part what you're about to say, which is then that's going to be the argument on behalf of Nancy is that, well, it was in Olivia's deed and that ran with the land. All right. And so then that's where your whole covenant and equitable servitude comes in. And then also because we're dealing specifically with the subdivision, the implied reciprocal servitude section is another area of law to do the same thing as covenants and equitable servitude, but it's just a bit of a more expedited analysis. But it's only applicable to subdivisions. Well, here we have a subdivision, so here that's what we should talk about. So the implied reciprocal servitude. So, Ashley, like this is what I would say is the culmination of the issue spotting process, right? Like you want to read the question, understand what's going on. You want to write your summaries on the left. You want to write down these topics on the right. And then it's time to now put that into an organized blueprint so we know what we're going to talk about and when. So I'm just going to, I wouldn't do this on the day of the exam, but I'm just going to erase this for space purposes. All right. So then now we have to figure out what are we going to discuss under question one? This is what claims and remedies, if any, may Reed reasonably pursue against Linda. So R versus L. So I'm going to look at all the notes that I took on R versus L. This is the whole life estate situation. Under the circumstances, I'm going to start off by just like laying out, that this is the, a life estate and a remainder. So that's from our present estates and future interest section. Is this a big issue in this fact pattern of trying to figure out if the remainder is going to vest and all that kind of noise?
no.
No. So this is a quick discussion, right? I'm gonna put a Q for quick discussion, but I'm gonna go ahead and just ground ourselves. All right. And then again, why is Reed upset? Reed is upset for waste. Is there anything else that Reed would want to sue Olivia for?
Um, no, I think it's just waste for
Yeah,
Reed.
that's it. That's the only thing he's interested in. And that's how you can confidently say that. There's nothing else that he's upset about. So, nothing else to be upset about, nothing else to sue about. This is how, when you're issue spotting, sometimes, Ashley, like, we get uncomfortable knowing how much there is to discuss for each issue. And the question of why are they upset and having comfort there gives you more comfort in, like, well, I'll stop here because there's nothing else for him to be mad about. We know the whole issue of her running the business is more so Nancy's issue. He's just upset because you cut down the trees and you made the house smaller. So I'm going to also showcase for you guys the legally fit folder system. And this is the type of thing that you use to help spot issues and then help go into further detail. So everything you need to know for property is in these four layers. Excuse me, in these 1, 2, 3, 4, 5, 6 layers. Waste, it first comes up in our materials in co-ownership of property, but it also applies in its unique scenarios to this life tenants and then remainders. But its main area of being tested is in co-ownership. So we're going to go into more detail and go into our co-ownership section. So we see that section 4 of co-ownership, one of them is waste. We don't have our detail there. So let's go to our 4th level. That's going to go into a little bit more detail. And then there we go. So we have 3 options: voluntary waste, permissive waste, and ameliorative waste. And then we can go into our outline if we don't remember the detail of each of those, but at least I have my 3 options. Under the circumstances, right, I probably would just put a heading for each one, considering that's all that's really the focus of prompt number 1. These are those type of judgment calls, of like, you know what, I'm just going to put down all 3. So you have voluntary, you have permissive, and you have ameliorative. For voluntary waste, this is about you doing something that reduces the value of the property. Do we have any facts for voluntary waste here, Ashley?
Reduces the value, yes.
What's the conduct that goes there?
The uh limiting the square footage.
I would say
So
that, yeah, well, let's see, the renovation to reduce the square footage. For sure, I would lead with, for sure, it's the cutting down of the trees, right? When you're
okay.
like taking down these valuable mature trees, that is, and you're removing stuff that's classic voluntary waste. And then under ameliorative, I think that one's going to be good as well. But ameliorative waste is whenever they're trying to change the property in a way that increases the value. But we don't even know if that's the case here because we don't know if the house is going to be more valuable as a business. But I do think this is definitely worth the discussion. Permissive waste is when you fail to upkeep something and that amounts to waste, right? Like the roof is leaking and you don't fix the leak. And so now the hardwood floors get messed up because the water comes in. So that was waste. We don't really have that here. So this one I, won't talk about in much detail. So there you go. That's question number 1. Question number 2 is, were the developer's residential deed restrictions valid? Now, this one's a tricky one. This is what I would consider a bar exam curveball. Have you learned anything in property law before, Ashley, that gives us a framework and a rule set for determining if deed restrictions are valid?
Yes, but can I recite it? No.
Please. Because I'm curious. I haven't. So please tell me, what have you heard as far as like restrictions on the ability to put in, deed restrictions?
Um, meaning like what would warrant the restriction or what makes it
No. So basically it's asking like, is that, can you do that? Can you put in this is only used for residential purposes? That's what it's saying. Was the developer, was their residential deed restriction, was it valid? So
I feel like,
could, mhm.
oh, I was just gonna ask, is this like a notice situation where, um, you know, by
Mm-mm.
virtue, oh, I'm going too far. Okay.
Going down a different path. Yeah.
Different.
Basically, all we're asking here is that can the developer do that? Can the developer put a restriction in these deeds that says you can only use this for residential purposes? So technically, this would be in our property law section. If we had a rule for this, it would be in property law, right? Under covenants. Let's go all the way down to our covenant section. When we get to covenants in our outline, we don't have anything on the type of covenants that are valid or not. We just have real covenant versus equitable servitude, how to determine if the covenant runs, right? Implied reciprocal servitude, right, etc. But there's nothing that we learn about when they're valid. So this is the type of question that requires you now to think on your feet and not spend too much time here. Ashley, let's be logical about this. Even though we don't have rules about it, what are some of the things that we can imagine are the type of restrictions that we could assume might be invalid? And this is now where you have to use like your creative legal brain for a second. Like, what is something that a landowner probably can't put into a deed as far as a covenant?
Um, like they can't require you to, I don't know.
How
Well,
about we're not, you can't sell this house to any minority in the future? Would that
fair.
like, would that likely be valid?
Right.
Right?
But
No, right? So valid.
meaning, right, like that would not be valid, right?
Exactly. So you're trying to think of something aggressive just to show the comparison here, because again, what you're dealing with here is I have no rule that prevents this. So now I'm thinking on the spot, and I'm simply going to say that like typically people are allowed to come up with whatever restrictions. Like that's all we've learned in all the hypos we've done in covenants, right? It's just like, oh, there's a covenant. You can't throw parties on the property. Oh, there's a covenant, that you lose the house if you don't graduate from law school. Like we've seen the freedom that people have in making covenants. So we have to lean towards this is probably valid. Exactly, Isabella. Nothing against public policy or illegal. But again, this is typically not a rule that you learn in law school or in bar prep, but we have to use logic to get through. So that's just like an example, everybody, of like we don't want to do when you get curveballs like this, you don't want to assume there is like this big rule that you just forgot. It's like, oh, this is like a curveball, and now I have to use logic to work my way through. All right. So I think this ultimately is a quick discussion. So I'm just going to put summary discussion here, but there's no particular area of property law. The other thing, the only other area of property law that's specific that comes to mind, it's the rule in present estates and future interest, and it's the rule about restrictions on alienation. You guys remember that rule? You can never give property in a way where you say you are not allowed to sell it to anybody else. Let's find that rule. Restraints on alienation. Absolute restraints on alienation are void. Reasonable restraints on alienation will be upheld. But again, that's on transferability, but that's the closest thing we have into bar prep materials on some type of like whether that would be valid. So you could bring that in as well if you'd like. All right, let's go back to our outline. So that's number 2. So I'm also going to do this quick. Number 3, this is where the points are, right? So 3, I'm going to start off with implied reciprocal servitude because that seemingly is the most important with it being a subdivision. But then I'm also going to talk about, excuse me, I'm also going to talk about real covenant and equitable servitude. We don't know what Nancy is suing for, money damages or injunction, but which one makes more sense here, Ashley?
Injunction.
Exactly, which means equitable servitude would be prioritized over real covenant. So I'll do equitable servitude first and then real covenant. but I would do those three in that order. And that, everybody, would be what I believe to be. We don't have the sample answer for this essay yet because this essay was just administered, but this to me would be spotting sufficient issues, and I would say all of the material issues for this essay. The bulk of my analysis is going to come in question 3. And again, you have your main issues like this big waste discussion and then question 3 as a whole. And last thing is, this is why time management is so important. Some of your most important issues are in prompt 3, but you have to analyze in order. So if you go through questions 1 and 2 gingerly and you run out of time for 3, that's how you end up getting a low score on this. All right. Do I recommend doing 3 first? Isabella, I in general am always a fan of not going out of order for anything. Inside of an essay, I don't like going out of order in my calls of the question. And even I don't like going out of order. Sometimes people will do question number 3 first and then come back to question 1 and do those type of things. So I'm always go in order type of person. All right. So we have now finished the read and stop and think section of this. We are taking our time going through this. I think we're getting some valuable lessons. We are a bit over time. We're at the 20-minute mark. So I want to give you guys an opportunity to obviously stay. I'll continue to go through just a bit of the writing phase as well. But if anybody does have other time, obligations or things they have to get to, this will be recorded and you will be able to watch the rest if you need to go. However, I'm going to stick around and we're going to now do a quick exercise on writing this out. All right, so let's go back to sharing screen. So now we've gone through and we have our issues. In theory, this would be now the time in which you would start writing out your essay. Here's the legally fit framework for what good writing looks like. Aesthetics and readability. How readable is your work product? Intros, which are like nice ways to introduce what you're about to talk about, and it sets the tone and sets a good impression for your grader. So intros are not worth points, but it's a good way to give you some good, brownie points and morale points with your grader that like, oh, this person, I could tell from this first paragraph, they're going to be talking about the right things here. And then next you have your rules. We all need to have our rules, analysis, and conclusions. As we know, all of these things are important, but the bulk of this is in your analysis. That's what we're going to do a quick exercise on right now. Most common issues with analysis: you go off track and you go on tangents, right? I'll give you some quick examples of each of these. Athena, ask me a question. Any question that you want to ask me, Athena, a personal question about me.
What did you do just before the meeting?
Well, yesterday, my stomach was hurting, and so I didn't get any good sleep. And so I woke up a little late today. And so I started off by going to the gym. And then all that to say, right before the meeting, I had lunch to get some energy, right? So what I did here is I went on a tangent. It was somewhat related, but I went off track. Bar essay writing wants, what did you do before the session? Before the session, I ate lunch. Period. Move on, right? And maybe you can go into the detail. I ate lunch. I had a peanut butter and jelly sandwich, right? With some coconut water. So that is the example of going off track or tangents. The example of conclusory, right? Athena could say, what did you have for lunch? I could say salad. Well, go in just a little bit more. I had a chicken Caesar salad with light dressing and romaine lettuce, right? Versus just being short and sweet. We talked about that difference between being conclusory versus long-winded. We have to find that middle ground. And then lastly is missing the argument or angle. That one's hard to do with that example of the lunch, but missing the argument or angle would be, let's do another example. Athena, If you were talking to, do you have a spouse?
I do.
Okay. So let's say you're talking to your spouse and you're trying to convince them that this is where we should go for dinner tonight. What is the way that you know is the way to butter them up to make sure you go get dinner at that place that night?
Well, honey, I know you love that steak at Anthony's, and I think it's on the special menu tonight. Maybe even $1 off.
Okay, love that, right? Knowing our spouse, we know that they like steak. We know that they're financially, focused and that a discount is going to be helpful. So if you know that, but instead you go with, oh, they play really good music in the background, right? Like that could be good, but that's not the angle to use here, right? So that's what we talk about as far as angles of like, you got to know the path of least resistance. Athena, the only way you know what works for your spouse is because you have the repetition and experience of doing it over and over. You tried talking about the music one time and he wasn't responsive. He or she wasn't responsive. So you're like, okay, that's not going to work. Let me stop with that. Right. And so once you see what works, then it's like, okay, I got it. He likes it when it's cheaper. So let me go ahead and mention that it's $1 off. So it's the same thing with bar essays, everybody. That argument or angle is easy, but it's the hardest one to acquire, and that's why you have to have so much time for bar prep. Because for every subject and all these topics, you got to know these arguments and angles for these discussions. All right. So those are our common issues. We're going to try to avoid them. So here we go. Let's go back to our fact pattern here. And let me put something in the chat actually. Let's stop share here. I'm going to give you your rules for implied reciprocal servitude. Let me give you guys a little excerpt from our outline. All right, so that's in the chat. You guys can all open that up. So open that up. And in addition to that, I'm going to share screen to bring back our fact pattern. Okay. All right. So you have your essay in front of you. I'm going to switch over to the outline, and you should have basically go to this section of your outline. Oh, I'm on remedies. Right here, the implied covenant. Nope, not the implied covenant. The implied reciprocal servitude. This is the section that we're going to analyze. This is exactly right in this outline how you more or less want to lay it out on your essay. That first part right there is your overarching rule. Then you have your sub elements, subheadings, and its rule. All you need to do is plug in your analysis, right? So you don't need to copy your rule for time purposes right now because I want to give you guys all 5 minutes. Let's go with 7 minutes. 7 minutes to analyze those three elements with our facts. So again, just kind of separate it out, but plug in your analysis. I haven't done this essay. Right now is the first time I'm going through it with you all. Just to show the comparison, I'm going to write it out in those 7 minutes as well. And then we're going to do a compare and contrast to what we both wrote out. All right, so you have your rules up. You have your question right here. So 7 minutes. Let me go ahead and get my timer. All right, your 7 minutes begins now. You're writing out the implied reciprocal servitude analysis using the rules and the fact pattern. Okay. All right. So let's go ahead and stop there for a second. Um, Isabella, were you able to write out a good chunk of that analysis?
Yes. I didn't type as much though, but yeah, I did some of it.
Yeah. So let's see. I didn't finish all of it. Again, 7 minutes. I didn't do this analysis before to know how much time was needed, but it goes to show just like how crucial speed is. And so let's compare how much I got out versus how much you got out, and then here's some of the analysis. So, how much did you complete?
I kind of completed like I didn't like do like paragraphs, but I just did like an outline of like what the issues were and what I think I would put. And then if it would be an exam, I would obviously be able to make it into like a paragraph format.
Oh, so we didn't write it out in a paragraph format.
Is that what I assumed that was like okay to do, just like kind of
Oh,
like issue spotting.
no, right now we wanted to actually write this out as if it was like our full analysis. Athena, how about you? Did you write it out as if it was a full analysis?
I did, but I was hurrying, so it's a little bit shorter.
Yeah, that time pressure was on. So did you make it through the entire discussion or did you fall short in that 7 minutes?
I made it, but I didn't have a very good introduction of it.
Okay.
Right.
So did you write out your analysis or did you type it?
I did. I wrote it by hand.
Okay, got it. Are you going to be writing the bar exam or are you going to be typing?
I'll probably be typing on my laptop. I'm just sitting at my desktop right now, and I try not to type on this one. I try to only type on my laptop right now.
Ah, okay, got you, got you.
Yeah.
Okay, cool. So let's go through our analysis. So first off, hopefully we did a breakdown of each element instead of a paragraph that tried to analyze all of them. So what was your analysis of the first element of common scheme?
I put down, I said, here there's a common planner scheme because developer conveyed each deed and was the original developer, the subdivision. Olivia had a deed with the recorded notice that the conveyance for the residential purposes, which was intended by developer, did so for all 15 lots in the subdivision under the common planner scheme, which was called Havenwood.
Okay, and was that the entire analysis just for the first element of common planner scheme?
For common planner scheme, yeah.
Okay, so I want to show you mine, and I would say that one is going to go on the category of long-winded. This is a
Yes.
very straightforward element within our discussion, and so we can be a little bit more direct. So here is my version. Zoom in and make this a little bit bigger. Let's also get rid of this. Okay, just scroll up is fine. Okay, good. Here, a common planner scheme is present because the facts state that Linda received her home from Olivia, who owned the home in Havenwood, a subdivision with 15 homes on large wooded lots. The court will find that this element is met. Period. Done. Athena, give me your thoughts on that comparison.
Much shorter than mine.
And
And
so, go ahead.
I think I actually included too many things that could go under intent and notice.
Exactly. Now, this Athena is off track and tangents. And this is kind of like a smart off track and tangent because you're just getting ahead of yourself to other things that are relevant, but in other
Exactly.
sections.
Yeah.
So again, part of the formula that we have is that you have to use this formula or whatever you do to basically stay locked in on just that question. So yeah, all we need here is common planner scheme. And then yes, that is a thorough, sufficient, to the point analysis. Nothing else is needed. We'll move on. All right. So let's go back to Isabella, and then I'll come back to you, Athena. Isabella, what was your analysis for intent? And hopefully, if even if you didn't write it out fully, can you give it to me verbally as if this was the essay? Like, how would that analysis look for intent?
Yeah, so like the developer was kind of like the original owner who had a agreement with Olivia that there would be a residential purpose. So he intended for that to be like with the other lots because they were all the same, and Olivia, and him were like in that type of arrangement. So there was an intent from the original parties to have it be likely to be transferred to the other lots.
Okay, not bad. Now again, I could tell that we were definitely just verbally articulating it as opposed to reading it. And so if that was what you had written down, what I would say to that one is kind of similar to Athena's. There's a little bit of fluff in there that's not giving us a just quick and direct 1-2 punch and out of there. So let's take a look at my analysis for intent, and you tell me what your thoughts are. Here, Nancy is going to argue that the developer intended for the covenant of residential purposes to apply to all buyers in the common planner scheme because the developer had conveyed each lot with this restriction and recorded all 15 deeds. The best argument is it was in every deed and he recorded them. And then my second punch cleanly is, moreover, this type of restriction in a subdivision is one that would naturally apply to all owners and future owners. The intention here was for the subdivision to remain a purely residential property. So, Isabella, what do you think of that analysis in comparison?
I think it's good because it's specific with the recorded deeds, and the fact that like it was all of them were applied in that way, and then you kind of like inferred that it should be implied because of, the um it would seem logical to have it applied to the other owners. So it's kind of like with specific facts and a little bit of like inference.
Yes. So let me explain to you all right here how I'm able to do this so quickly, right? Number one is that my structure is templated. My structure for the analysis is always the same, right? You guys are going to have to come inside of Legally Fit to get what exactly our analysis framework is, but you can deduce what that is by just looking at the two analyses that we've done so far and see the similarities. But the way that I start, look, every time I start with here, right? And then even how I go from there is routine. So my structure to just get started is templated. This is kind of like your Kickstarter. I don't have to think, oh, what am I going to write? I know I'm having a fill in the blank analysis template, right? So structure is fill in the blank analysis template. Then on top of that, I'm using cataloged arguments, right? So specifically for intent, and it's in the outline as well, right? For intent, the first thing you're looking for is any type of language in the contract that is going to apply to other people. We don't have that language in contract. Then you can look at also behavior, or you can look at nature of covenant, nature of what you're dealing with. So I looked at behavior first, and the behavior was, oh, he gave this to everybody and he recorded it. That's behavior. So I know, look to be for behavior, find the behavior, put it in. And then look at the nature of the covenant. What's the covenant? The covenant here is that this is going to be for residential purposes only. Oh, this is something that would naturally apply to everybody. So now I talk about the nature of the covenant. So the next time, Isabella, you get a new hypo, and it's like Athena has a subdivision, and everybody in the subdivision gets the same deed that you cannot park your cars in the garage. Excuse me, you cannot park your cars in the driveway, right? So now when you're analyzing that for intent, I'm going to say here, so and so is going to argue that the developer did intend for this parking restriction to apply to all homeowners because one, it was in every deed to every homeowner in the lot, and two, the idea of this covenant of no parking in the driveway would be one that applies to everybody. This covenant is to assure the aesthetics of the neighborhood, and this would likely then apply to all current owners and future owners. So again, right off the hip, because I'm just repeating the same type of argument I've seen before. All right, and then third, let's go ahead and just show what the notice element would look like, and I'll just do this one, and hopefully we all caught this. So I'm going to do a quick counter argument, because again, that was what we were saying was the basis of the argument. Linda's going to argue that she had no actual notice because there is no mention that the restriction on residential purposes only was in her conveyance, right, from Olivia. That's her argument. I had no actual notice. However, Nancy is going to argue that Linda had record notice because the developer recorded the deed from D to O, right? So yes, that's record notice. The house that you're getting, it has been recorded on that property that this covenant is in there. And then I was going to talk about inquiry notice, but that's where I then ran out of time, which again is showing you where I kind of stopped off around that 7-minute mark. And yes, the inquiry notice I would have argued is not as strong, but I would have said, moreover, there was inquiry notice because one would reasonably notice that there are no businesses in this area and that there's only homes, and so that they would inquire further about this before starting a business, right? Whether it's a winning argument or not, that is the, logical argument. So you would be able to include that.
Professor Aubrey, we're not seeing your answers. Are you showing us them? We're seeing the question one.
Oh, this whole
Sorry.
time. This whole time I was showing you guys mine. Okay, hold on. Let me stop.
Maybe it's on your side. I can't see him over here. Double check with anybody, someone
I
else.
can see the answer as well.
Yeah.
Okay. So I was
I can
sharing
see
both at
Lynn's
the
here as
same
well.
time, Athena. So you probably just had to move over to it. Okay, perfect. But yep, and it should be up there now for you because I stopped sharing the question. All right. So as we wrap up now that quick exercise, the takeaway, everybody, again, is a reminder that everything that we just did and how I went through it and even how I write it is a product of systems. The way I'm able to write that much amount in 7 minutes with that level of accuracy and efficiency is not me in that moment thinking through it. It's like, yes, I've done intent before. This is what I do. I've done notice before. This is what I do, etc. So that is what is going to be the focus inside of Legally Fit, is sharing with you all the strategies and then giving you the proper ways to practice them so that they can become secondhand for you. So for all those that missed on Monday, just to give you guys the quick steps for what you can do next, we have our repeater assessment and strategy call, which is a 1-hour call that's going to be on Zoom. And so if you want to jump into your writing and the areas in which you're struggling and need to improve, we can do that. I can help you interpret your scorecard. And then ultimately, we can create for you, whatever program you're doing, a customized attack plan based off of your skills and your circumstances. If you're working, if you're a parent, if you are a caregiver, if your score was over, 100 points off or over 50 points off for the UBE or whatever it may be, we can talk about your needs and circumstances and what a personalized attack plan would look like. If you have just some quick questions about Legally Fit's program and we can squeeze that into 15 minutes, then you can book a free 15-minute consultation call where we can discuss the program and answer any of the specific questions. We do have 2 programs, our live program that's highlighted by live workshops every week, where we basically do stuff like this at a much faster rate because we'll have our systems down. I won't be teaching you the systems every week, but we'll be practicing them and getting live feedback. We'll be building our MBE skills, essay skills, and PT skills. And we also have office hours for questions. That program is $5,000. And then Bar Prep on Demand, you still get all the strategy, all the materials, but you don't get the live workshops or the office hours. So it's a bit more of a self-study, self-paced version. And that one is 2,500. We do have 1 day left for the discount. We started it on Monday and it was a 3-day discount where you get $500 off of the live program and 300 off on the on-demand program. But that is that's going to end by tomorrow evening. So if you want to sign up, might as well get that discount before it expires. All right. If you have any questions, you can always reach out to Monique. She handles all of the customer support. That's ma@legallyfitstudent.com. And if you're on Instagram or TikTok, give us a follow. We're always posting new events that we're doing. We'll probably have some free events during bar prep as well. So you can follow us there to make sure you see those. And yeah, that is everything for today.
And we'll be
Um,
back tomorrow.
oh, and we'll be back tomorrow for breaking down the bar multiple choice. Before we wrap up and I open it up to everybody leaving and Q&A, I do want to end with my question of what was your takeaway from today? One of your biggest takeaways from today? I'll start with Athena.
You're muted,
I
Athena.
was just signing up. I think what I've been struggling with is how to get more concise and not be rushed during the essays. And just having a system where I can rely on the same steps every time is something I've really been looking for.
Yes.
Yeah.
All right. All right. Ashley, what about you? What was your biggest takeaway from the lesson that we learned today on essays and strategy and et cetera? Oh, I think Ashley might have just left. Yep. All right. I'll go to Isabella.
Kind of also what Athena said about being concise, because I struggle with like going on and on and on. And it's nice to see that like you can have one sentence for like an issue or something and like a minor thing, and it's enough for the essay to be getting points. So, and I also liked the fact that you can have the issues and the summaries like broken down in that way. I didn't think of it like that before.
Yeah. And I want to talk about that just for a quick bit, on again, that confidence of knowing when and how much you have to be like detailed, right? Because Athena, right? Let's say you were trying to convince your spouse to go to dinner. Well, in that conversation with that person, price is very big. So you're going to embellish on that in that circumstance. Oh, the stakes are only this much. Oh, it's happy hour right now, so it's going to be cheaper. Oh, this and oh, that, right? And then if you mention music, it's just like, oh, yeah, and they have good music. But let's say then you're talking to me. And now it's like, DeAndre doesn't care about the money as much. He wants the vibe and the ambiance. So now I'm going to talk about music. And now I'm going to talk about the type of music. And it's live music. And it's not too loud, but it's this and that. Now you're giving more detail there and you're skimping on the price part. So that is kind of what is both the challenge, but also the freedom that once you get confident with your writing, everybody, that is how you then confidently navigate your discussion of when you are super short and sweet, right? It's like, this is a non-issue. Common planner scheme, Athena, that's not an issue here. We know this is a common planner scheme, but I do need to discuss it. So yes, this is a common plan because the facts state this was Havenwood and it's a subdivision with 15 lots. All right. I don't need to embellish more there. But when I get to this notice discussion, right, or this intent discussion, I know this is typically the elements that are more at play. So I'm going to embellish that more. So very good takeaway, Isabella. And the add-on that I want to give there is that is part of the creative freedom that you have to then step into once your confidence grows, is this knowing when I could be super direct, short and sweet, and when to embellish. Awesome. All right. So yeah, we can go ahead and end that there as far as the takeaways. Thank you guys for coming. I'll see you all tomorrow. And then I'll stick around for just an additional, 5 minutes or so if there's any follow-up questions. But yeah, hope to see you all tomorrow and I hope to see you all in our program where we're going to be doing this stuff and more to make sure we're successful on that next bar attempt. All right, you guys, take care. And then, yeah, if anybody has any question, they can either unmute and ask or put it in the chat.
I'm
Hey,
gonna
I have
answer
a
Disha's.
question. Can you hear me?
Oh, sorry. I'm gonna answer Disha's question. She asked about the link for tomorrow. If you RSVP'd, it is the same link, and you will get a reminder for tomorrow's event as well. Okay, I'm sorry. Go for it.
Me?
Yes.
Yes.
Okay, thank you. I'm in EBA jurisdiction, so your contract law and property outlines is going to be suitable for the UBE takers.
Yes. Yeah. So everything about what we did is the exact same for the UBE. Yes. So today, just for our purposes, today we just used the California essay, but that size of a fact pattern is very typical of a UBE exam. And like I mentioned, for UBE purposes, you would just imagine that instead of all three calls of the question, you might have just had one or
Okay.
two. But the way you analyze and our formula, all that stuff, our UBE students have used to pass just the same. The biggest difference, again, is just you don't have to write as much for the UBE exam. There's not as many issues.
So there is no changes in property and contracts for California and UBE.
There's no change in priority of contracts.
And property and
Contracts and
contract.
property law.
Oh, no, no, no. Yeah, the law is the same. And right, the for the UBE versus California, California, right, we have the same multiple choice as the UBE. And then California, again, that law is the same. We just have a few additional topics. And UBE used to have a few additional, but this summer they got rid of them. You no longer have secure transactions. You no longer have conflicts of law, right? And those other ones. So yes, the law is going to be equivalent.
Okay, thank you so much for the
You're very
answer.
welcome.
Have a
There's a
great night.
question in the chat, DeAndre, about the
The
Texas
Texas
bar.
bar, would the class I signed for be tailored for it? Yes. Yep. We just had somebody pass the Texas bar, not this past administration, but the one before. But we've helped plenty of students with the UBE. And again, the essay formula is the same. The multiple choice part is literally the same. The PT is literally the same. So the only difference, again, everybody, between the California and the current form of the UBE bar exam, not the next gen, but the traditional form, is that the essays are 30 minutes longer. And all that is for California is that you're talking about more. There's more issues triggered, but you're still applying the same pre-writing strategy. You're applying the same writing formula, the same way to write for the bar exam. All of that stuff is the same. It's just less in 30 minutes than the full hour. All right. Well, it looks like that is it for our questions. So you guys all have a great evening. Kudos to you all for sticking it through. I know we went over a little bit, but that's because the information was flowing. We were having a great session and learning. So again, this is another little bit of investment into your success. So good stuff today. And I'll see you all back here tomorrow for the multiple choice breakdown. All right, you all have a good evening.